Mr. Brickhill.
Chairperson, Commissioner Mabena. We apologize for the delay this morning. As I will explain in a few moments, at the close of proceedings yesterday, there was a request from the evidence leaders that SERI and the ICF provide some additional documents relating to the ESP issue that I was dealing with at the end of the day.
Yes.
We were able to procure those documents, and we have prepared two packs. They are before you as exhibit proposed SERI 11 and SERI 12. But I will get to them if I may.
Are they these?
There should be three documents before you, Chairperson. One is a further and we promise final version of our proposed draft recommendations.
These are further amended draft recommendations.
Indeed, sir. And this we hope will be the final proposal, and I will explain the changes that have been made to the version that we provided yesterday. And then there are two further packs of documents, stapled documents, which should be labeled Exhibit 11 and Exhibit 12. They may be labeled 10 and 11. It should be
Exhibit?
SERI 11 and SERI 12.
It's 10 and 11, according to what is written here.
We understand there was already a 10.
Also, this should be Exhibit SERI.
So
where there is a 10, it should be 11.
Indeed so, Chairperson.
And where there is an 11, it should be 12.
That is correct. And
yes.
Chairperson, if I may, well, perhaps for housekeeping purposes, I should just confirm whether there is any, the attitude of the evidence leaders and the city to those proposed exhibits. My understanding is that there's no opposition. My learned friend for the evidence leaders confirms, and my understanding is that the city doesn't oppose.
Mr.
Chair, we do confirm we don't have any issue with the introduction of this document.
That, Chair, is the case with the evidence leader.
Thank you. Mr. Brickhill.
Thank you, Chair, and thank you to my colleagues. Chairperson, I'll get to the contents of the documents in a moment. In order to do so, I need to start where I left off yesterday. It's also necessary for me to clarify submissions that I made at the close yesterday, because it appears that I may have conveyed something that I didn't intend to convey as far as the evidence leaders and the city are concerned. Chairperson and Commissioner, at the close yesterday, I was dealing with examples from Mr. Mahlangu's statement of unlawfully occupied buildings where the occupiers, through their committees, have concluded agreements with the city for the provision of services. What I did not seek to convey, and I do not submit, is that those residents were receiving ESP benefits. They were not. They were receiving services that they were paying for and not yet receiving ESP. So I wanted to be absolutely clear about that and avoid any
Would this relate to the three buildings that you alluded to being Manhattan, Argyle, and Koch?
Indeed so, Chairperson.
Okay.
Indeed
now,
so.
that is quite clear, because what was surprising to me, to the recollection of the evidence before me, was that I didn't have that evidence.
Indeed so, Chairperson, that the evidence previously of Mr. Mahlangu, in particular in his supplementary affidavit, was that residents of 7 other buildings, 357 of them, had registered for ESP but were not receiving it.
Yes.
So we have that evidence.
Yes.
Then, if I may take the Commission, it would be helpful to take the Commission to the relevant part of Mr.
Yes.
Mahlangu's statement dealing with Koch. So if I could please take us to page 875 of the SERI witness bundle.
Page
875.
yes.
Chairperson, if you'll just bear with us, we should be able to project it onto the screen. Chairperson, if I may, I'll just ask if there we have it. Okay. Page 875. So, Chairperson, Commissioner, this is Mr. Mahlangu's main statement. We're at paragraph, if we can go to paragraph 143. And this is dealing with Koch Mansions, Chairperson. And there had been a disconnection of water services previously, and also a dispute over the provision of electricity. In paragraph 143, Mr. Mahlangu records that on 8 September 2021, the occupiers signed an acknowledgement of debt with the city, in terms of which they agreed to pay a sum of 230,726.62 in monthly installments. If we could just continue. In monthly installments of 6,592.15 cents, and the occupiers are making payments in terms of the acknowledgement of debt.
Yes. Not as an EHP, not as an ESP.
They're not receiving ESP benefits yet, Chairperson, but if I may, I'll deal with that. So, Chairperson, Exhibit Seri 11 that we have now provided, if I may take you there. Chairperson, you will find here 2 acknowledgements of debt and then a letter. And perhaps it's helpful to start with the letter on page 4 of Seri 11. It's a letter from Seri to the city from attorney Mr. Mdabe. And Chairperson, what the letter records is it refers to the acknowledgement of debt dated 11 June 2018 and attached, and confirms that in this agreement we confirm the arrangement between the City of Johannesburg and our clients, effectively that the clients will continue to pay for historical debt in the amount of 8,449.19 monthly and for current use of electricity. These terms relate to water and electricity at Koch Mansions. As part of the arrangement, we would pay for services and receive a monthly statement of account for payment made to the city. And paragraph 3 requests that the city provides the statement so that the community of Koch Mansions may be informed of how much they owe. And paragraph 4 further confirms that the statement requests that the statement should be provided to Mr. Mlungisi Zenzile, and his ID number is provided, who is the committee leader at Koch Mansions, and a copy of his ID is attached. If we could then just go back to, please, to paragraph where we were, page 876, and to paragraph 144. Oh, and Chairperson, just for, I should have referred to it, the acknowledgements of debt at pages 1 to 3 refer to Koch Mansions, and on the second page, page 2, you'll see they're signed by a tenant and then signed by the city. Chairperson, I wanted then to refer to the remaining details of the arrangement that we have. In paragraph 144 of Mr. Mahlangu's statement, he describes how the occupiers then deal with paying the monthly statements. And he records that the occupiers do not pay rent, but each household contributes approximately 800 Rand monthly towards services, rates, and taxes. They receive a statement of account from the city indicating how much is due in respect of services, rates, and taxes. They then divide the amount by 56, being the number of units, to calculate how much each household must pay. And then copies of the statement are attached, and those were already attached, Chairperson, as annexures ICF 16 and ICF 17. Those are the statement and proof of payment. And I would ask that we please go to page 957 of the SERI witness bundle. Thank you. So this is the relevant tax invoice, one example of one being issued in respect of Koch Mansions to the occupiers. And if we scroll down, you'll see that the previous balance is recorded. And if we could please go to the second page, on page 958. We'll see first the Joburg water meter reading and billing. So that's a total amount for the whole of Koch Mansions, and the same under City Power for electricity. And what I would draw attention to is that under City Power for electricity, just below halfway down on those entries, Chairperson, there is a line item for expanded social package. In fact, it appears twice
Yes.
on the invoice. Against that, there is a 0.
Yes.
So what the invoice reflects, we would submit, is that the residents are not receiving the expanded social package. But we would submit, it confirms that the system of the city is capable of allocating that expanded social package benefit as against the invoice to the property. If there were a registration for ESP for this property that the city recognized and was implementing, that amount would feature on the invoice and be deducted in the ordinary way. That's the way that Mr. Kosa and others explained that the ESP is administered as a rebate against the invoice. So to be very clear, Chairperson, we're not suggesting that that is already happening, that
Yes.
occupiers.
Your submission yesterday was different.
If it was, Chairperson,
You are correcting it
I'm
now.
correcting it. What our submission is, Chairperson, to be very clear, is that the city has entered into arrangements of this sort with occupiers through their building committees for the provision of water and electricity. The sort of consumer agreement that is contemplated in Section 3 of the Standardization of Electricity Bylaws. It's competent, it's lawful for the city to do so. And it's just one step further then to recognize ESP beneficiaries who register appropriately, who qualify under the ESP, and to include their benefits on the invoice. It would then be, as Mr. Mahlangu describes, for the occupiers to divide among themselves what remains to be paid to the city. So in Koch, it's divided by 56. They've been managing that. It's working for the occupiers. It's working for the city. The piece that's missing is that some of those occupiers ought to qualify for ESP, and they're not receiving it. And we would extrapolate that across the other buildings. It's what the ESP is meant to do, and we submit that there's simply a blockage in the city's implementation that needs to be addressed. And there's no further reason why that can't be done, other than an apparent unwillingness to do it. What appears to be the case is that there's a resistance to doing it for occupiers in inner city buildings. It is done in informal settlements where ESP benefits are provided, or free water and electricity are provided, but it's not being done in unlawfully occupied properties. Now, and we would emphasize there's nowhere in the ESP that it says that unlawful occupiers are not entitled to the benefits of the ESP. In fact, the ESP benefit emphasizes that its benefits are meant to go to non-account holders, to the poorest residents of the city, including in high-rise buildings. And Chairperson, this accords with the approach in Grootboom and later cases. It's the most vulnerable, those in the most desperate position who should be benefiting, who need the benefit of these services where they qualify. So, Chairperson, that, and I should just deal briefly with with Exhibit 12. It's simply a further example. So Koch Mansions, Chairperson, is legally a sectional title with 56 units. 55 of them are owned by the city. So it's effectively a city-owned property with unlawful occupiers in dispute with the city about their occupation, but where they've concluded an agreement with the city for the provision of services and are servicing that debt, while the eviction proceedings or that dispute continues towards resolution. The second building, Chairperson, is Wolpert Motors. That is a privately owned property, and a similar acknowledgement of debt is provided in Exhibit 12, and there follows a proof of payment. It's a similar arrangement, tenants reaching an agreement with the city. The only difference is that it's a privately owned property. And again, we have proof of payment. And to be clear yet again, they're not receiving ESP benefits yet. But we would submit that the residents would include people who qualify for ESP and ought to be receiving it. So the same submissions would apply. So those were the examples, Chairperson, that we were able to provide in response to the evidence leader's request that we furnish the sort of agreement that I was talking about yesterday, the type of consumers agreement. And these are some examples, both buildings that were inspected by the Commission, both within the terms of reference. Chairperson, those then are our submissions on the ESP. We've dealt with the three main substantive issues that we wanted to deal with, which were the term hijacking, but more substantially the paradigm, the framework that's used for policy, for thinking, for implementation in relation to the inner city. Secondly, ICHIP and its status and its implementation. And thirdly, basic services, the ESP, and the provision of those services. Chairperson, it remains for me to deal very briefly with, in conclusion, our proposed findings and recommendations.
Yes.
And Chairperson, those are set out in our written submissions from page 132. And I will deal with them briefly and not repeat submissions that I've already made. Chairperson, we, in these sections, address proposed findings and recommendations, which the Commission is called upon in terms of its terms of reference ultimately to make. And these are the ones that we would propose. So on page 132, Chairperson, we begin with proposed findings, and we deal first with lack of access to housing. And Chairperson, it has emerged as common cause that there is a lack of affordable housing. What we propose in this section is that the Commission respectfully make such a finding, and we attempt to quantify it. In our submission, the best data available, Chairperson, is still the ICHIP research, which found that there were approximately 30,000 households at risk, households in need of adequate housing in Region F in the inner city. Now, that was research that was done prior to 2017, so it's likely that the figure is higher, and that was the evidence of Mr. Makola and Mr. Nkwane, that the numbers in ICHIP may have gone up, including in terms of people. But we still submit that this is the best data that the Commission has in terms of quantifying what is the need for affordable housing in the city. And many of those 30,000 households, Chairperson, would be people who are living in the buildings that the Commission inspected and in other similarly situated buildings or in informal settlements. So we're talking about the same people, but what we're focusing on here is the number of people, the number of households, rather than the number of buildings, which I'll turn to in the next section. So our submission there is that the Commission make a finding that there is a lack of access to affordable housing in the city, and that approximately 30,000 households are affected. Chairperson, you'll recall that ICHIP, on that basis, proposed programs that would deliver around 9,500 units. So it would meet about a third of the need over 5 years. And I'll return to ICHIP in due course. Chairperson, the next section on findings deals with questions of prevalence. And we've listened to our learned friends' submissions. It is a difficult question in terms of identifying the numbers of buildings that fall in the different categories. And Chairperson, we would emphasize here too that it isn't a single number that the Commission is looking for. Because of the way the terms of reference are drafted, dealing with buildings that have been abandoned or taken over by criminal syndicates, two different scenarios, and that may have or may not have access to basic services and may or may not be unsafe, there are actually different questions. It isn't a single number that there are, say, 200 buildings, whether you call them bad buildings or anything else. There are different discrete findings that we would submit are required to be made in terms of prevalence. And we accept that it's a difficult set of questions to determine definitively in terms of the inner city as a whole. But we have sought to take it as far as we could by focusing on the inspected buildings. And Chairperson, in the end, based on the evidence leaders' submissions, it's our understanding that 74 of the inspected buildings, and we're at paragraph 337 of our heads, 74 of the buildings that were inspected fall squarely within the terms of reference. They were understood to be so. And of those, Chairperson, there were only 5 properties where there was any allegation of rental being collected. So the Section 2.1 of PAI offence. There were complaints of that, or allegations in relation to 5 properties. And then in relation to at least 60 properties, Chairperson, representing 81%, over 81%, there were fire safety concerns arising out of the inspections. And then the final category that we looked at was buildings that lack basic services. And that was at least 50 out of the 74 buildings. So approximately 67.57%. That's at paragraph 337.3 of our heads of argument. Chairperson, in this regard, we also recall the evidence led by Ms. Royston in the SERI main statement and the 3 data sets that were provided there on prevalence across Johannesburg as a whole and in the inner city. And we would commend that data also to the Commission in grappling with these questions of prevalence across the city. We draw two big picture conclusions in terms of findings in relation to prevalence, Chairperson. The first is that the presumption that all the buildings are quote unquote hijacked in the sense of unlawful illegal rental being collected is not borne out by the evidence. And in fact, the evidence reflects that that is a relatively small proportion of the buildings. It has always been, am I audible? It has always, Chairperson, been SERI and the ICF's case that illegal rent collection is a problem in the inner city. The evidence was that the ICF has referred specific instances of it to the SAPS. We also led Dr. Wilhelm Solomon, who confirmed that instances of criminality do arise in the inner city buildings. But the point, Chairperson, is that the scale of that has been generalized. It's been presented in the public domain in particular that this is the situation in every building. And the evidence we would respectfully submit simply doesn't bear that out. What it bears out is that, according to the inspected buildings, approximately 6.75% of buildings have these allegations. Chairperson, in extrapolating that to the inner city, it's difficult to determine. The evidence from GFIS was not particularly helpful on this score. And so it's difficult finally to make a numerical finding on how many buildings involve illegal rent collection. We would submit that the Commission should appropriately find that that does occur in the inner city, but that it occurs in a relatively discrete proportion of the buildings, and certainly not a majority, certainly not all of the buildings. So that's the first aspect on prevalence, Chairperson. The second, Chairperson, which is very strongly borne out by the data on the inspected buildings and all of the other evidence, is that fire safety and lack of basic services are very widespread across the buildings that fall in the terms of reference. In relation to fire safety, over 81%, and in relation to basic services, over 2/3 of buildings lack some of the basic services. And so those practices are particular, or those circumstances are particularly prevalent. And we submit that the question of prevalence must include those findings. It's not limited to illegal rent collection. Prevalence, in the way the terms of reference are framed, relates to all aspects of the buildings as described in the terms of reference, including fire safety and lack of services. And we would respectfully submit that the Commission should appropriately make findings on prevalence on those issues too. Chairperson, the next set of findings is concerned with resources and budgeting, on which there's been significant argument too. And we would submit that to a large extent what we propose here in terms of findings is also broadly common cause. The central proposed finding is that the city has failed to allocate from its own budget or to secure from provincial or national government the financial resources required to administer its own housing policies. And Chairperson, that was not disputed. Mr. Makola, Mr. Nkwane accepted that the city had simply not budgeted enough, certainly to implement ICHIP or even to administer the city's own TEA. They explained that that is due to constraints that the city faces, but the fact that the city has not allocated or secured enough funding to administer its own housing policies was not disputed. And in particular, I've referred to the TEA's point that Mr. Nkwane and Mr. Makola accepted very readily that the city hasn't allocated anything like what is required to administer the 9 or more TEAs that the city is currently operating. And the evidence was that the city had budgeted only 80 million a year for housing, with 11 to 15 million for TEAs in recent years. Chairperson, I see that that subparagraph is not footnoted. The relevant references appear in the summaries of Mr. Makola and Mr. Nkwane's evidence in the earlier section of our heads of argument. But that was their evidence in relation to the amounts allocated, the 11 and 15 million. And I've dealt with ICHIP, that the city failed to allocate the 1.3 billion required over the 5 years, not a single year, but over the 5 years, which comes to approximately 260 million a year. What we get, Chairperson, from their evidence is that they were allocating a figure closer to 80 million a year. So about 1/3 of the ICHIP costing was being allocated. Now, while that's obviously inadequate, what it does show, Chairperson, is again that ICHIP was not a pipe dream, that it was broadly realistic. The city was allocating about 1/3 of what ICHIP had costed. And it's our Chairperson, it appears that these batteries do not last for 2 years.
We need Mr. Craig.
We need Mr. Craig back with his special batteries. Chairperson, just to complete my submission on ICHIP, and I'll return to it in a moment, but on budgeting and allocation of resources, our submission is that the city has fallen short, and we referred to Commando, Blue Moonlight, Grootboom. The city has fallen short, but what has been proposed, what is envisaged in ICHIP, is not of a different order of magnitude. We're not talking about 10 times, 100 times the amounts. We're talking about amounts that are affordable. And I'll return to that in a moment when I deal with recommendations. The next theme, Chairperson, that we deal with is criminal conduct and so-called hijacking. And I've made the submissions on the term being unhelpful and the proposal that it should be abandoned. And I've dealt yesterday in full with what the evidence reflects in terms of actual investigations and prosecutions of the offence under Section 2, subsection 1 of the PI Act. We quote Section 2, subsection 1, which creates the offence, and we summarize the evidence in terms of really very few to zero investigations and successful prosecutions. We also make the point there, Chairperson, is that what we have had evidence of, and we've seen an example of it now in Koch Mansions, is confirmation of committees and residents collecting funds among themselves to manage processes of cleaning, security, and in cases like Koch Mansions, to pay towards services and other common costs. And we make the submission there that this practice is not unlawful, and in fact it's helpful in maintaining the condition of buildings. And it's effectively residents stepping up to look after their own conditions, taking responsibility for their own lives, and appropriately so. It's certainly not unlawful. Chairperson, lessons learned we don't deal with in any detail in our next submission. We accept that there are a number of lessons that could be extrapolated from the findings and the recommendations, and they would really flow naturally from the findings and the recommendations. We highlight one big picture lesson that we submit emerges from the Commission as a whole, which is that a systemic lack, and we set it out in paragraph 344, page 137 of our heads, that a systemic lack of access to affordable housing and the failure to provide basic services to poor residents exacerbates the risks that they face and ultimately creates the conditions for buildings to become overcrowded, dilapidated, and risky. So we're really refocusing on what we understand to be the key causes of the poor conditions, the risks, the unlawfulness and crime in the inner city. And they can really be tied back ultimately to the lack of affordable housing and failure to provide basic services. Chairperson, we then deal briefly with responsibility for this state of affairs, just trying to identify who among the relevant role players would be responsible for different aspects of the findings. Chairperson, in our opening statement, our written opening submissions, and indeed in our closing submissions in part 1, we dealt with the two terms responsibility and liability in some detail, and you'll recall we compared them to other commissions of inquiry and the language there, and looked at those authorities. We haven't repeated those submissions. The nub of those submissions was that responsibility and liability must mean different things because both terms are used, and that liability is really talking about civil and criminal liability under the law, whereas responsibility is somewhat broader. And we focus here on responsibility because we think it's more helpful in part 2, rather than trying to identify civil and criminal liability, although those may arise, particularly under the bylaws. But the focus really is on responsibility for the state of affairs and addressing it. And in terms of who's responsible for different aspects, we deal with that in paragraph 346. For lack of affordable housing, that would be primarily the city, although, and we don't say it here, but provincial government and national government also bear responsibility, given our authorities and Grootboom that it's all three spheres of government that are required to deliver affordable housing, and that the programs that are involved, like the EHP and the social housing program, operate at both national and local government levels. So perhaps an annotation to include province and national in relation to the lack of affordable housing, but primarily it's the city. In relation to basic services, again, it's primarily the city, but also specifically its relevant entities, including Joburg Water and City Power. In relation to poor fire safety in buildings, this would be primarily building owners and the city and its entities. Chairperson, we would also accept that the occupiers bear some responsibility for fire safety. And when I deal with recommendations, our recommendations include occupiers being recommended to act in some of the buildings where they live. Finally, Chairperson, responsibility to enforce bylaws, that rests primarily with the city and private property owners. So, Chairperson, if I may then turn to the recommendations, and to do so, I propose rather to address our Appendix B. Chairperson, I'm conscious that we started late and have probably now gone into tea time. We're in the Commission's hands.
Yes, you may proceed.
Thank you, Chairperson.
What time is it?
It's 11:26, Chairperson.
Yes, you may proceed.
Thank you. So, Chairperson, if the Chairperson and Commissioner Mabena have before them the final version of Appendix B that we shared.
Further amended.
And indeed so, Chairperson. And I'll draw attention to one change at the outset, which is also a way to ensure that everyone has the correct version, because it's a change that we've made throughout. We're alive to input that we've received from the evidence leaders that the proposed recommendations looked a little bit too much like a draft court order, and in particular the peremptory language. So we had drafted initially using the term must. We have now replaced that throughout the recommendations with the word should. So it still has some force to it, but we would accept that these are obviously in the nature of recommendations that go to the executive to be considered. And Chairperson, we had regard overnight to the final report of the Marikana Commission of Inquiry, and that was the language that it used. It used either the language of it is recommended that someone does something, or the language of should. The South African Police Service should. So we have followed that instance, and we consider that language is more appropriate than the peremptory must. Chairperson, if I then address the recommendations that we propose, and these are set out in our heads of argument too, but have been distilled into Appendix B. The first, Chairperson, is that the city should take reasonable measures to provide affordable housing to those who lack access to housing in Region F of Johannesburg, including allocating appropriate budgetary resources and developing and implementing reasonable plans. Chairperson, we submit that there's nothing the least bit controversial. This really just tracks Grootboom and the latest reiteration in Commando of the city's constitutional obligations. It's also what the city has accepted that it bears as an obligation and has said that it is already attempting to do. But we submit that it is appropriate to make a recommendation regarding affordable housing, given its centrality to the issues. Chair, paragraph 2 of the recommendations, again, is drawn from submissions, in fact, made by all of our learned friends, all of the other role players, in terms of the other relevant government actors. So my learned friend for the city referred to the role of COGTA and that it has an important role to play. And the Human Rights Commission in its submissions also addresses the other spheres of government and their role in working with the city to provide affordable housing. It's also a point that the evidence leaders have made, and we accept that point from all of our colleagues and have therefore incorporated this paragraph 2, which proposes that the city should engage with those actors, national and provincial departments of human settlements, the national and provincial departments of COGTA, and the presidency, and that the incorporation of the presidency is a response to the evidence leaders' submissions relating to the presidential task team that was recently established. So the submission effectively is that the city needs, in fulfilling its role, to engage with all of these players. Chairperson, in paragraph 3, we refer to our Appendix A, which is the recommendations for the specific inspected buildings. Chairperson, I don't intend to take the Commission to those or take you through them in any detail. They speak for themselves. There are just two aspects that I must highlight. And first of all, we've made the submission that in relation to the evidence leaders' proposals around bylaw enforcement and the issuing of notices and compliance, We take no issue with those recommendations. Where we had discrete submissions on particular ones, we've made those. But broadly, we accept the bylaw recommendations. What we have done in our Appendix A, Chairperson, is make 2 further sets of recommendations building by building. And broadly, they relate to fire safety and to basic services. And in a nutshell, Chairperson, they are that the Commission should make recommendations for concrete steps to be taken in relation to fire safety in each of the inspected buildings, and the same for basic services. Chairperson, this is born out of an observation which we submit arises very clearly from all of the evidence that we've seen, which is that bylaws don't enforce themselves and that the issuing of notices of compliance doesn't necessarily produce the desired results on its own. It's an important piece, but there needs to be a direct focus on fire safety, at least in the buildings that we all took the time under the Commission's leadership to visit and inspect. So that's the first aspect. The second is basic services. We've pointed to the fact that 2/3 of the inspected buildings lacked some or other of the basic services, and we submit that having made those factual findings arising out of the inspections and in the evidence leaders' reports, there should be recommendations to take steps to provide basic services in those buildings, including ESP benefits, free or subsidized services, where the residents qualify. So that deals really with Appendix A, Chairperson. In paragraph 4, Chairperson, we make recommendations relating to ICHIP. And these really flow from my earlier submissions on ICHIP. Again, there's been a slight adjustment to respond to concerns raised by the evidence leaders. We submit that the city should review, update, and present ICHIP to the relevant city authorities, such as the Mayoral Committee and Council, as the law may require, for consideration and adoption. If I may pause there, Chairperson. This proposal of reviewing ICHIP was, in any event, the evidence of Mr. Makola and Mr. Nkwane. Their bad buildings strategy already says that ICHIP is to be reviewed, a 5-year review is to be conducted. So we're making a recommendation here that it aligns with what we understand to be the city's commitments already. I dealt in some detail yesterday with the question whether council approval was required. We stand by those submissions in terms of council approval not being legally required for ICHIP to be implemented according to Mr. Makola's evidence. But we're alive to the practical implications, which the evidence leaders in particular have referred to and drawn to our attention, which is that in order for ICHIP to succeed, in order for it to be properly budgeted for, it needs to have the support of council. Council needs to be aware of it at a practical level. So even if Mr. Makola may be correct that a plan of that nature doesn't legally require council approval, we accept the evidence leader's position that it would be appropriate and beneficial for ICHIP to be taken back to the city's council following the process of review. So mayoral committee and council. Mr. Makola did in any event, and my learned friend Mr. Sidumedi indicated this, it was envisaged previously that it was going to go to council. Mr. Makola said for noting, not for approval. That will be a process for the city to determine whether noting or approval is required. But the recommendation is that it should indeed go to the mayoral committee and council. And Chairperson, in 4.1 to 4.3, we've just provided some detail of what that review process ought to do. We submit that this would arise naturally from any review process. First of all, that it should assess and update the targets for delivery under the housing programs of ICHIP. So those 6 programs that ultimately targeted 9,500 units, those should be assessed and updated. The need may be greater, and that this should include reviewing their costing, and we've incorporated their chairperson within the available resources of the city. We accept that qualifies the city's obligations, and we've made our submissions on the law in that regard. Chairperson, we've suggested in 4.2 that 6 months would be an appropriate process time period for this process of review.
How long did it take for the ICHIP strategy strategy to be developed?
Chairperson, I would have to review, but it was certainly in excess of a year.
Yes.
But that included substantial research, the team doing interviews, surveys, and so on. It would depend whether the review process involves doing all of that research again or a more limited desktop
Yes.
review.
I'm alive to that. That's why I'm concerned about having to put them to terms of 6 months.
Chairperson, we certainly take that point, and what we've endeavored to do, Chairperson, well, let me start here. We have a concern that without recommended time periods, we will see what has happened with the
Yes.
problem properties bylaw,
Yes.
which has been under review for...
Yes.
There may be a way of either softening the recommended period in some way, a reasonable period, not to exceed a year.
A year.
Yes, Chairperson. And it may be that the city has appropriate input on what a period should be. If we were, one recalls the sort of debate one has in court around a period of suspension of an order of invalidity. And this is a similar sort of process.
Yes.
And we would ordinarily then look to the state to say how long they need. That wouldn't be determinative. It would be for the Commission to decide what is a reasonable period.
Yeah.
But the city may have input there. We've suggested 6 months. Chairperson, 4.3 just deals with ICHIP then being presented to the relevant authorities at the next available opportunity after it's been updated, so that they may consider whether it's the mayoral committee and/or council to consider whether it should be adopted. Paragraph 5, Chairperson, deals with the bad buildings strategy. And it's a similar proposed recommendation that the city should review that strategy to bring it in line with its overall plan in ICHIP. I made the submission yesterday, Chairperson, that ICHIP is really the overarching umbrella strategy. Bad buildings strategy is one piece of that, and it needs to align with the reviewed ICHIP. So if the city is to review ICHIP in terms of paragraph 4, the bad buildings strategy would also need to be reviewed. And we also endorsed the submissions of our learned friends for the evidence leaders yesterday, that the bad buildings strategy appeared to be being administratively implemented but hadn't been really completed in terms of its process. Finally, we've made the proposal in paragraph 5 that the process of reviewing the bad buildings strategy should include engaging with inner city residents and suitably qualified independent experts. That had not happened initially when the bad buildings strategy was developed, or not adequately, we would submit. Chairperson, I should correct that submission. I recall that Mr. Makula's evidence was that there were meetings with civil society actors in the process of developing the bad building strategy, so there was some involvement. We would submit that that needs to happen again when it's reviewed. Chairperson, paragraph 6 then simply deals with the consequent step of implementing ICHIP once it's been reviewed. And there are 2 parts to that, Chairperson, which we submit are important. The first is that it should not be an unfunded mandate. ICHIP mustn't be left, as it was before, in limbo, unfunded. And the city, after reviewing it, including itself determining appropriate costing within its available resources, must then take the logical next step of allocating the budgetary resources determined by its own process of review in order to implement ICHIP. And Chairperson, the second element there in 6.2 arises from ICHIP itself and also from the evidence of Dr. Wilhelm Solomon and Professor Cousins. And it was an issue also raised with them and with other witnesses by the evidence leaders. It's around the lack of coordination. ICHIP itself proposed what we set out here, a program coordinating committee, which we submit, drawing on the evidence of those witnesses and the city's witnesses too, should include at least representatives of the Department of Human Settlements, the city's planning department, the Department of Social Development, EMS, Emergency Management Services, and then JOSHCO, JDA, and the JPA. as well as suitably qualified independent experts, the sorts of people who were involved originally in the development of ICHIP. But it would be for the city to establish that program coordinating committee and determine suitably qualified and appropriate people. ICHIP itself recommended this. Chairperson, we would submit that the evidence shows why this was so important and why it was needed. Because what we hear from Mr. Makula and Mr. Nkwane in particular is that parts of ICHIP were implemented. Some forward programs were implemented partially, but there was simply no coordination, no tracking of the achievement of its targets, no monitoring and evaluation. And that would be the role of this program coordinating committee, which would pull together those different programs, track progress, possibly recommend changes and review as things go along, because we understand that these processes are complex. But to us, that would be a crucial aspect of successfully implementing ICHIP. Chairperson, paragraph 7 then deals with TEA, and the recommendations there really again flow from the evidence and submissions already made. The first aspect is for the city to make use of the emergency housing program where applicable in relation to funding TEA. And we understood, our learned friends for the city yesterday, to accept that in principle they're open to doing so. They made the submission that the EHP requires ad hoc applications for one particular situation. That may well be the case, but the point is that it's a vehicle and a potential source of funding for the city to explore, and we understand that the city is open to doing so. That's the first aspect. The second aspect, Chairperson, really just relates to the conditions and basic services in the TEA, that those need to be addressed. We made the submission yesterday that with the possible exception of Fraser House, they really are a great cause of concern at the moment, that the city's own TEAs are in very poor condition. 7.3, Chairperson, deals with management of the TEAs and the city's loss of control, that it needs to address that situation. That would include access control and general management of the TEAs, having a presence there, ensuring that there's appropriate supervision. Paragraph 8, Chairperson, deals with social and affordable housing. And there are two aspects to it. Again, making use of the EHP and other policies and instruments where appropriate. And then crucially, Chairperson, to take steps to ensure that persons earning less than 3,200 Rand per month are prioritized in the housing units which would be made available. And this goes back to Josh Coe and the evidence around the balance in the provision, Chairperson. And it's not for us, nor for the Commission we would submit to dictate exactly those proportions, but simply that there needs to be appropriate priority for the poorest section of the community in the provision of social housing. We would accept that that must be within Josh Coe's overall model. The model needs to be financially viable and survive. We accept that the higher income earners cross-subsidize the lower income earners, but it can't be, as is currently the case, that there simply aren't any units available for this lowest income band below 3,200 Rand, that there isn't any availability at all. So that those are our proposals in relation to social and affordable housing. Chairperson, paragraph 9 deals with basic services. And the first aspect, Chairperson, is simply around engaging with committees and organizations to do what I was dealing with earlier in my submissions, to devise a process which is the next step from the agreement already reached in Koch Mansions and in the second building, where basic services can be provided, but including now the ESP, where people register and qualify under the ESP. 9.2 deals with the provision of basic water and sanitation services in terms of the Water Services Act and its regulations. 9.3, Chairperson, crucially focuses on electricity. The proposal there is that the city should review the implementation of the ESP, not its terms, its terms present no barrier to inner city residents receiving its services. It's the implementation, it's how it's being used in practice. So review the implementation of the ESP to ensure that it achieves its own objective of providing free basic electricity and subsidized electricity to poor residents, including non-account holders, by introducing processes to install meters and other necessary infrastructure, and establish arrangements with resident committees or residents' representatives to provide ESP benefits to residents of inner city buildings where the owner does not facilitate access to electricity. So, Chairperson, it's for the city to introduce appropriate practical solutions that ensure that those benefits reach the people that they are meant to, including non-account holders. And I've made my submissions on that issue earlier. Chairperson, 9.4 finally deals with refuse removal and the bylaws regarding refuse removal. There's nothing that's in contention there. In paragraph 10, Chairperson, we make some proposals regarding the problem properties bylaw. And really, Chairperson, and I'm alive to your questioning earlier around time periods, but it's about recommending that that process needs to come to a conclusion. Chairperson, you engaged my learned friend for the city on it yesterday. We've proposed 3 months to complete that process so that then the bylaw can be amended and or implemented. And that if there's a decision that it needs to be amended, Chairperson, in 10.2, we suggest that that ought to be possible within 6 months. And we would submit that that's a fairly generous period to simply amend a bylaw. It's not a national parliamentary legislative process. Chairperson, paragraph 11 deals with engagement with residents and committees generally. And it was addressed in argument yesterday. We've made the submission that it is not constitutionally appropriate for the city to say we will not engage with any of the residents of any of these buildings that are unlawfully occupied. We made the submission that the engagement obligation in Olivia Road actually applies to unlawful occupiers, not to anyone else. It doesn't apply to lawful occupiers. And the experts spoke at length, Chairperson, about the value of this kind of engagement. It's one thing to stick a bylaw notice on the front entrance, and the residents may discuss it and engage with it in a certain way. It's a different thing to actually speak to people, to take steps, to arrange meetings, and Mr. Nkwane has talked about doing that in some instances. Go into the buildings, actually engage with the residents, ask for their cooperation to comply with bylaws, to deal with other issues that may be of concern, and it's a two-way process then, which the experts spoke to as being particularly important in changing the conditions, improving the conditions in the buildings. Chairperson, paragraph 12 then deals specifically with engagement around fire safety. And this would be predominantly the role of EMS. We had the fire chief speak to the training and community engagement that they already do. Our recommendation is that this should be included in the recommendations as something that the city and EMS should focus on, both in terms of the inspected buildings and other similarly situated buildings.
What happens in buildings where there are no committees or organizations?
Chairperson, we accept that that may make the process more difficult, and it may be that EMS finds it difficult to arrange a meeting with residents, but until they try, they don't know that, Chairperson. So we're not suggesting that this is a peremptory requirement, and if they fail to do it in every building, there's some kind of breach of a legal obligation. What we're submitting is that they say it's what they do, but the evidence from that the Commission received is that it's not happening in many of the buildings. It would have benefits, and at a systemic level, they should attempt it. The ICF also made the undertaking, Chairperson, to facilitate that, and that undertaking stands in relation to the 40 buildings where they organize. I imagine that SERI would also assist in buildings where it represents occupiers. Chairperson, it could really make a significant difference in terms of fire safety, that residents then have experts from the EMS, firefighters, coming in to talk about the importance of keeping exit ways clear, of having a fire safety evacuation plan. What will you do? Do you have people on the building committee who are responsible, who have whistles to draw attention and help people to evacuate in the case of emergency? Chairperson, that really links to paragraph 11, where we deal with fire safety recommendations. And this arises from Mr. Gregg's evidence too. And it's really based principally on his evidence, but also other evidence from EMS and others. Chairperson, the first and it's really a package of fire safety recommendations. I should make one submission up front on these recommendations, Chairperson. We do not say that these are things that the city alone is required to do. These are recommendations that must go to all of the relevant role players. That includes the city, private owners, and indeed occupiers. Occupiers have a responsibility for their own safety, and some of these steps are steps that occupiers should be advised to take by the Commission. So in the first paragraph 13.1, we speak to rooms should be constructed with fire containment compartments by using fire-resistant partition doors to reduce the risk of fire spread. That recommendation would go to anyone who's constructing buildings, Chairperson, and it's really just saying that the Commission has identified this as best practice. It's not saying the city at its own cost needs to now go out to every room and do this immediately. We don't make that proposal. It's rather identifying that this is the best practice that needs to be rolled out moving forward. Where the city is the owner, it would be the city's responsibility potentially. Where there's a private owner, it may fall to them. And then in 13.2, Chairperson, we propose that the package of fire protection measures that Mr. Gregg spoke to, which should include the installation by owners or the city or occupiers, first of all, of domestic-type battery-operated smoke alarms and small portable fire extinguishers in each room where feasible. Now, Chairperson, there were concerns raised about the cost of doing this. Mr. Gregg's evidence were that these items cost respectively 250 Rand or 400 Rand. They're available for those. So the smoke alarms were 400 Rand. I may be mixing up, but one is 250, the other is 400. Just clarify with my junior chairperson.
250.
400 for the fire extinguisher,
Yes.
Chairperson.
That might be a small amount of money to you, Mr. Briquet. You are an advocate. But to a tenant who is unable to buy food and put on the table for his or her children, it might be a difficult task.
Absolutely, Chairperson. We've discussed it at some length in our team in making the proposal. Again, this isn't a court order, which would say that every occupier must do this within 3 months. It's a recommendation that the city, private owners and occupiers should take steps to procure these items. Now, that might happen incrementally. It might be that the city is able to have some pilot projects let's take the TEAs, for example. The city bears a particular responsibility for those TEAs. It created them, it put people in them in the discharge of a constitutional obligation. Perhaps in relation to the TEAs, it would fall to the city to roll out fire extinguishers and smoke alarms. And in the context of the city's budget, Chairperson, even in the context of the 80 million being allocated to housing, this is not an unaffordable or excessive amount for those buildings. In relation to occupiers and owners, Chairperson, again, it may be that it's rolled out incrementally, that building committees are able to do collections, and we say, okay, we've identified that the top floor is the highest risk, it's the most difficult to get out of, to exit from in the building. We'll take a collection and we'll start there, and perhaps we'll start in corridors with smoke alarms, or we'll start in some of the rooms with children. And we'll prioritize those. There are ways of doing it incrementally where over time, we reach a situation where it becomes common that inner city buildings have these small, more affordable fire extinguishers and the portable smoke alarms with the 2-year batteries that we've heard about. And Chairperson, just the impact that those could make, we heard from our learned friend yesterday for the evidence leaders about a further fire that has taken place. The impact that these could have is really tangible. We're talking about many other systemic things, but in terms of safeguarding lives, we submit that these could really make a very big difference. And it could be that it could be clearer in our wording where that responsibility lies, but I trust that I've conveyed what we're intending to achieve by this, that all of the role players should attempt to procure these. It may be that there could be donor funding, or the private sector could also contribute. There are creative ways of achieving these objectives. Chairperson, the second item relates to the installation of fire sprinklers. We've described them as relatively low cost. As I recall, these are closer to 3,000 rand, so the cost is higher. And we've proposed that recommendation be issued to the owners or the city or occupiers, as the case may be, to install the fire sprinklers. And again, affordability may be a bigger constraint here, but it is a salutary recommendation we submit, and that these role players should attempt to take it forward where they are able and where they are responsible for buildings. Chairperson, the third aspect refers to educating, encouraging, and enforcing the preservation and maintenance of fire safety systems by the city. We've already made a recommendation on that issue. It just re-emphasizes it. And Chairperson, paragraph 14 attempts to resolve the difficulty that you've raised, which is how do we achieve these practical measures on fire safety and whose job is it? And in our submission, the answer is to be achieved through engagement, which we recommend in paragraph 14. So there could then be a process of engagement in relation to each building between the city, where applicable, a private owner where they are in the picture, and the occupiers, to say, well, the Commission has recommended that we look at installing fire extinguishers, smoke detectors, and sprinklers. And the city might ask, what are the occupiers able to do for themselves? The city the occupiers would rightly ask, I think, what is the city able to contribute? And there would be a process of engagement, which would ultimately, we would hope, lead to the rollout incrementally of these items by all of the relevant role players. And Chairperson, it really is also in the interest of property owners, whether it's the city or private owners, to install this fire safety equipment, because it safeguards their own property too. So they have an interest. It's not just about helping occupiers. They have an interest in protecting their own property, and it may be that interest is enough to motivate, for example, private owners to say, okay, well, we will install the fire sprinklers, and we'll leave it to occupiers to put smoke detectors in your rooms. But we're not trying to be prescriptive. It can be left to be resolved by the role players building by building, but the recommendation we submit is vitally important. Then, Chairperson, in paragraph 15, we deal with law enforcement and policing, and we've dealt with this in our heads. The first aspect in 15.1 is a recommendation that effectively the policing authorities should desist from doing what the Constitutional Court in Industry House found was unlawful, which is using police raids as a means to deter people from living in the inner city, or as a means of evicting them without complying with the PI Act. And
do we have this kind of evidence before us?
We do, Chairperson. So
Yes.
first of all, we have the judgment of the Constitutional Court in Industry House, but Dr. Wilhelm Solomon also spoke to the issue of policing raids. And his evidence, Chairperson, was that these raids had been commonplace during his 10 years of research in the inner city, and also that they were not achieving their stated objectives. The stated objective was to identify illegal rent collection. But as we've seen, there have been almost no investigations or prosecutions. Instead, what you have is what the Constitutional Court found as a pattern of conduct in Industry House, which is repeated raids into people's homes in the middle of the night, rounding people up, a few people being investigated and prosecuted for minor offenses such as immigration offenses, but really nothing much more. And Dr. Wilhelm Solomon's evidence was that there are problems of crime that affect occupiers, and that what's needed is targeted, intelligence-driven policing. And that's the next recommendation that we make at paragraph 15.2. That if the target is illegal rental collection, then the way to police that is not by 50 police officers conducting a midnight raid, going room to room in every room. You're not going to find any evidence that will secure a prosecution for illegal rent collection that way, but intelligence-driven policing that targets the actual offense, rather than residents generally across the board. And the Constitutional Court's explicit finding in Industry House in relation to the city of Johannesburg is that raids were being used for an ulterior purpose, to deter people from living in the inner city, effectively to chase them away. Chairperson, paragraph 16 is the sort of proposal that we might often see in a structural interdict. It's a proposal that we make with a view to the Commission's recommendations ultimately being effectively implemented.
Yes.
We have all seen commissions of inquiry where there are real challenges in implementing the recommendations. My learned friend Mr. Semenya and I and Seri were involved in the Marikana Commission, and it's an ongoing process still to this day to secure different implementation of its different recommendations. So in paragraph 16, we've proposed that the city should engage with committees and organizations of occupiers, as well as organizations representing occupiers, to form a committee that will be responsible for ensuring compliance with the Commission's recommendations in Part 1 and Part 2. So
Yes,
establish
what
some kind of...
happens with regard to buildings where there are no committees or organizations, and where there are no legal organizations representing those occupants?
They would then not be part of such structure as the committee would establish, as the city would establish. There may be some scope to still engage with them and invite them to participate and encourage them. Personally, I've been involved, especially when I was an attorney, in many processes to help to establish those committees. It's often church leaders or often other community leaders who come into a building and facilitate that process of electing a committee where there isn't one. So there are ways of making it happen. But this committee would probably need to have representatives from buildings that have already been identified. And there may be other role players that the city considers should be on such a committee. And it would be for the city to determine who should be on it. They may want people from different departments. They may want their legal representatives. But the central idea, Chairperson, is some kind of structure to monitor what the Commission recommends. Not like a court, it wouldn't have those powers, but just as a way of following up under the city's own jurisdiction and powers. It would be a city committee, city-convened committee, to ensure that it takes forward the recommendations and that they don't gather dust. And that can sometimes happen not because of ill will, but just because of the lack of this kind of focused coordination and follow-up. So that's what paragraph 16 seeks to achieve. And Chairperson, in paragraph 17, we've again just tried to keep all the role players honest by suggesting that wherever the Commission recommends a first step, a meeting, or something to be done, it should happen within 2 months.
You're going a bit too far here, Mr. Brickhill.
That may be so, Chairperson.
Yes,
that may be too aspirational.
And of course, one has to be alive to the fact that this is a commission and not a court.
We would accept
and
that,
it may take the Premier 6 months to 6 years to consider this commission's report.
Chairperson, we would hope that it wouldn't take 6 months or 6 years to convene a first meeting to discuss it. It may take 6 years to implement.
But it is outside the realm of the commission to say, Premier, you must take less than a month to consider this report so that this recommendation is implementable.
Chairperson, we would accept that. We would concede that. And we would submit that in any event, the real body of the Commission's report is likely, given everything that we've heard, to convey the urgency and importance of the issues without needing to be prescriptive.
Yes, up to now, I haven't heard anything about our recommendation in respect of part 1.
Chairperson, we do address it in our written submissions. And in fact, it may be that we even proposed a recommendation, which I now see is not included expressly in Appendix B, which was a recommendation that the city should follow up on the Part 1 recommendations.
But it is within the Premier's powers,
It is,
not the city's.
I stand corrected, Chairperson,
Yes.
for the Premier to follow up on the Part 1
Yes, it's for the Premier,
recommendation.
not the city.
Indeed, so. But we did address it, and it was a matter of some concern that some of the Part 1 recommendations don't, and Mr. Semenya raised it yesterday, don't yet appear to have been fully
Yes.
implemented. And we would submit that it is appropriate and competent for the Commission in its Part 2 report, which is the final report drawing it all to a close, just to draw attention to the Part 1 recommendations. They're not, the two parts are not hermetically sealed in a way that Part 1 can't be touched or referred to anymore. It would be appropriate we submit to make a recommendation to that effect. And Chairperson, our final recommendation in paragraph 18 relates to what I addressed in submissions yesterday, which is to desist from using the term hijacked buildings.
Yes.
Chairperson, those are our submissions. If I may just check with my team whether there's
Yes,
anything
you
that I
may.
haven't addressed. Chairperson, it's been drawn to my attention that there's one further omission. Again, it's included in our heads as a proposed recommendation, but it's not in Appendix B. It relates to the acting appointments.
Yes.
And if I may address that briefly, we frame a proposed recommendation in the section of our main heads on this. And we listened to the city's submissions on it yesterday. Again, the proposal would not be that the Commission impose something entirely prescriptive or uncompromising, inflexible in relation to the filling of acting appointments. We recognize that they play a role, that there will be times when there are of people holding positions in an acting capacity. But what emerged very powerfully, we submit from the evidence, is that this is a systemic problem, that there are senior positions across the city's entities and the city's departments occupied for extended periods on an acting basis, and that the recommendation should be that the city pay attention to filling those as soon as possible. Again, that wouldn't, I think, I submit, intrude into or create the concern that the city raised yesterday, that the Commission is somehow impugning every acting appointment. The circumstances will differ, but it's about the systemic concern that acting appointments should be filled.
Yes.
And we would submit that it would be
the city itself has raised in its evidence.
Indeed so, and Chairperson, with respect, the witnesses, you could tell that it was a real matter of concern for them on a daily basis. Witnesses like Mr. Nkwane, that both he was acting and many of his, the people reporting to him were acting or the positions were vacant, and how that was affecting the work he was trying to do and what he was trying to achieve. So we submit that this, again, would be a recommendation in line with the city's own concerns, its evidence, and it can be framed in a way that recognizes that acting appointments are still necessary at times, but what you cannot have is the sort of systemic set of vacancies that appeared. Chairperson, those then are our submissions.
Thank you.
We're indebted to the Commission.
Thank you,
and to
Mr.
our colleagues.
Prickle. I think we'll take an adjournment for a late tea. What time is it?
It's 12:09, Chairperson.
Mr. Semenya, what do you propose? 15 minutes. Oh, sorry. Before I call you, Mr. Siminya, I think it's Ms. Sitole's time. Yes. Ms. Sitole?
Good afternoon, Chairperson. Good afternoon, Commissioner Mabena. The Human Rights Commission extends its gratitude to this Commission of Inquiry for allowing it to participate in these proceedings, including the inspections in loco. We make these oral closing submissions in a form of recommendations. We have read and observed with interest the submissions and propositions of the other participants, and will make appropriate responses, either highlighting areas of agreement or highlighting areas of disagreement. We do so in an effort to assist this commission in narrowing the issues to consider. To avoid confusion, I will refer to the South African Human Rights Commission as the Human Rights Commission, and this Commission of Inquiry as this commission.
Yes, as we both share the same name.
Yes, Chairperson. The Human Rights Commission plays a crucial role in supporting constitutional democracy with a specific mandate to promote, monitor, and protect the attainment of the rights entrenched in Chapter 2 of the Constitution. The Human Rights Commission executes its mandate by investigating, reporting, and making submissions on its observance of human rights, including submissions to Commission of Inquiries such as this one. For understandable reasons, Part 2 of this Commission of Inquiry has focused on the prevalence of buildings such as Usindiso in Region F, the inner city of Johannesburg. We submit that at the heart of looking into these buildings is the issue of the right to housing and the right to access to basic services. And we submit that, as the Constitutional Court put it in the case of residents of Industry House, which has been referenced by Mr. Brickell, a home is more than brick and mortar. It is often a place of comfort, safety, and a keystone of a functional society. And this we have witnessed through the oral testimonies of some of the residents in the occupied buildings. And we've also witnessed during the inspection in locos conducted by this commission in over 100 buildings. And this inspection in locos confirmed that these buildings are more than just bed buildings. They are homes to thousands of people in the inner city, including vulnerable groups such as the elderly, women, and children. It is the Human Rights Commission submissions that the right to housing is a fundamental aspect of that we find in Section 26 of the South African Constitution, which is aimed at ensuring that every individual has access to adequate housing as a basic human right. Section 26 of the Constitution is rooted on the premise that housing is an integral part of human dignity and well-being of individuals, as well as a means to secure other socioeconomic rights. The constitutional mandate recognizes that housing is not merely a shelter, but encompasses a range of elements, including security of tenure, availability of services, affordability, and location that provides access to employment and social amenities. This was again confirmed in the Constitutional Court decision of Joe Slovo. This holistic understanding of housing goes beyond mere physical structures, as it addresses the quality and adequacy of living conditions and emphasizes the necessity of a supportive environment that enables individuals and families to thrive. It is based on this understanding and premise of what Section 26 means that the Human Rights Commission makes submissions that the state at various levels, particularly at local level, because that is the government that is closest to the people, is tasked with the responsibility of progressively realizing this right, which involves taking reasonable legislative and other measures within its available resources to achieve the full realization of the right to housing. Mr. Brickell went in detail yesterday looking at the Blue Moonlight judgment on what the court said about the state using the measures available to it and the resources available to it. So I will not take that point any further. Safe to say that this means that the state must develop policies and programs aimed at providing housing opportunities for all. And the framework of the right to housing is also supported by various other legislative measures, which we have put in detail in our written submissions. This includes the Housing Act, the PI Act, and the Housing Code. These legislative measures outline the crucial responsibility of the state to facilitate the provision of adequate housing effectively and to establish necessary norms and standards for sustainable housing development. But perhaps most of all, these legislative measures are important to maintain the constitutional balance between the right to housing in Section 26 and the right to property in Section 25 of the Constitution. As the city grapples with significant challenges related to pervasive housing inequality and rapid urbanization, the implementation and strict enforcement of this fundamental right remains absolutely critical in addressing long-standing historical injustices, promoting overall social cohesion within communities across the city. It is important for this commission to always have at the back of its mind the historical and social context and the purpose of the right to housing. This includes the right against arbitrary evictions. It is common cause that segregation and apartheid depended to a great extent on controlling where Black people were allowed to live, depriving them of access to land in white South Africa and crowding them into rural Bantustans and urban township. The result of the apartheid legacy is that millions of South Africans occupy land or buildings that they have no common law rights to occupy. Many have been driven and are still driven to move into land and buildings to which they have no right because they simply have nowhere else to go. Again, Chairperson, these are some of the things that we heard from some of the occupiers during the inspections in local. Unlawful occupation is a social phenomenon that is likely to persist for the foreseeable future. It is thus essential for the state at various levels to implement measures to prevent homelessness and to ensure the provision of basic services. And as the court held in the case of Mkhontowana versus Nelson Mandela, there can be no doubt that municipalities bear an important constitutional obligation to provide water and electricity to the residents as a matter of public duty. This commission, during the inspections and during the testimony before it, has had to deal with the issue of temporary emergency accommodation. It is our submission that temporary emergency accommodation is a critical component of the broader strategy to ensure the protection of the right to housing in South Africa, particularly for vulnerable populations. TEA serves as a stopgap measure that provides individuals and families with essential shelter while long-term housing solutions are being developed. And this, Chair, I submit is an important part of TEA that we have seen during the course of part 2 of this commission. It has lagged from the city's side. We have found in inspections buildings that have been occupied as TEA in over 10 years. That simply cannot be because the housing ladder needs to go up. The effectiveness of TEA is thus intrinsically linked to the role of municipalities, which are tasked with the responsibility to implement policies that are not only provide immediate relief, but also facilitate pathways to permanent housing solutions. We submit that although TEA is not a permanent solution, as pointed out by the parties, particularly the evidence leaders, its effective provision can serve as a foundation for the progressive realization of the right to housing and ultimately contributing to efforts aimed at combating homelessness and achieving a more equitable housing landscape. It is thus imperative that the city is equipped with the necessary resources and frameworks to effectively manage TEA initiatives, ensuring that they align with national housing policies and reflect the human rights standard embedded in the Constitution. The next part of our submissions, Chairperson, just give an overview summary of the inspections. And these have been explained in detail by the other participants in this commission. And what we find is common in the overview of the inspections is that they reveal the recurring theme of a derelict state of buildings, mostly resulting in owner abandonment, which has led to a lack of basic services and a vacuum in responsibility for maintenance and the provision of basic services. We have found in the inspections in loco that the occupants occupying these buildings are largely indigent persons who are unable to independently address the severe issues in these properties, at least not without the assistance of the municipality or recognition by the municipality, as we have been told by our colleagues at SERI with Goch mentions. There has been a constant finding in the inspections in loco of the absence of basic services such as running water, reliable electricity, and proper sanitation facilities. Most occupiers resort to communal taps, fetching water in buckets, and inadequate or non-existent ablution facilities. The evidence provided by the occupiers in some of the buildings primarily focused on the lived experiences of the residents in the inner city of Johannesburg. It also included the challenges that they face with accommodation and finding, or rather, getting access to low-cost housing. And it also indicated that the occupiers or residents' interactions with the city regarding their living conditions have not yielded any results. The oral evidence of the occupiers, it is our submission, paints a grim picture of life in some of the inner city buildings, highlighting the vulnerability and resilience of residents facing challenging living conditions. Lastly, the inspections underscored the human cause of urban decay and the critical need for systematic change to address the housing crisis in the inner city. And that change needs to, we submit, come from the city. And moving on to giving a summary of the evidence provided by the city. Chairperson, you would recall that the Human Rights Commission only requested to cross-examine 2 witnesses of the city, that being the acting municipal manager and the acting executive director of human settlements. And this summary encompasses what we're able to get or not to get in their oral testimony during cross-examination. Broadly, the city accepts its failure in fulfilling its constitutional obligations. We've seen this in their written statements as well as from Mr. Stumedi's submissions yesterday. The city has lamented that it has challenges arising from financial constraints and human resources capacity constraints. This is an issue raised by Mr. Stumedi and this morning by Mr. Brickell on the worrisome issue of having a high-level positions being acting stints for a long time. You would recall, Chairperson, that during the evidence of, I think it's the Executive Director of Human Settlements, he had only been acting for about 3 months at the time of giving his evidence.
Mr. Nkwane.
Mr. Nkwane, thank you, Chairperson. In relation to its TAs, the city has considered the neglect and dilapidated state of the TAs. It has also indicated that its TAs are full to capacity. This was also is what we confirmed during the inspections in loco. It is our view that this is part of the problem, as the city has not taken proactive steps to advance the housing ladder and treat TAs as the first step to affordable and permanent housing. None of its TAs occupants have been audited or placed in other forms of housing. To give an example, Chairperson, we inspected one of the city's TAs, MPV1, and we learned that in MPV1, the occupiers, they were relocated there, I think they're about 2008, and they've been in a permanent state of temporary emergency accommodation. We agree with the evidence leaders that there must be a discernible and attainable plan by the city to achieve the realization of the right to housing. We submit that the city has not provided this commission with real plans to do so in future. The only steps provided to this commission are those taken by the city in relation to the moth building, which conveniently took place during the time of this commission, despite the city knowing about the problems in moths for at least 5 years. Chairperson, you can find that in the interaction between myself and the acting municipal manager. The transcript page references 1518 at para 20. The city has considered that the measures presented before this commission are measures taken in the duration of the inquiry. The evidence provided by the city shows that the city has shortcomings in the measures that it has sought to employ in realizing the right to affordable housing and providing and maintaining TEAs as well as basic services. The city's evidence lagged in showing the measures taken in the last decade to prevent the proliferation of bed buildings and to enforce its problem property bylaws. The most the city could tell this commission about its problem property bylaws was that it could not be enforced because there was legal advice. Well, in the written submissions, they said there was an ongoing litigation. But in my engagement with Mr. Makula, he then said that they had received advice that the problem property bylaws might be constitutionally suspect insofar as land expropriation is concerned. Chairperson, you will find that engagement with Mr. Makula on the transcript at page 1526, para 10. And it's clear that there is a contradiction between his oral and written testimony on the ongoing litigation. And Mr. Makula could not provide, in cross-examination, timelines on the steps the city has taken in reviewing the problem property bylaws that we are meant to believe are being reviewed in the last decade. All this commission has is that the problem property bylaws are being reviewed. There is a concern that there might be constitutional suspect insofar as land expropriation is concerned, and that Mr. Makula, when he started his acting stint, he instructed that they should be tested out to see if indeed they do pass the constitutional muster. The evidence shown by the city reveals a lack of institutional memory. And this again, Chairperson, speaks to the issue of acting stints being in the high positions within the city. And I just mentioned, for the purpose of these submissions, the municipal manager position as well as the executive director for human settlements within the city. We submit that institutional memory, particularly for a state entity such as the city, with the obligations that it holds, is important to carry out, for the city to carry out its legal duty, especially in the recent past where we have experienced persistent change in leadership. This is evident by the fact that the acting municipal manager and acting head of human settlement who have testified before this commission could only assist this commission with plans and measures taken only during their acting stints. This begs the question we submit as to whether these plans and measures will outlive their acting stints, or if future municipal managers will even care to continue to implement the findings of this commission. Most concerning about the city's plans, perhaps, and its measures, is the myopic belief that in order for the city to execute its constitutional obligations and mandates and address the issue of built buildings in the inner city, it must conduct warrantless searches and seizures. which we submit have not yielded any results, any tangible results in the past, except for a gross violation of people's right to privacy and dignity, as was found in the case of residents of Industry House. And as correctly stated by Seri, this approach was rejected by the Constitutional Court. We submit that this approach by the city is regrettable because it criminalizes the poor and it sees them as passive participants in a process that is supposed to include them as it involves their constitutional rights. And based on these observations that the Human Rights Commission have made, we then make the following recommendations. Chairperson, these recommendations are in our written submissions. I'll just try and summarize them for the purpose of our oral submissions. I won't go to all of them. I think they begin at page, I'm just looking for the page number. They begin at paragraph 74 of the written submissions, which is page 20. We summarize our recommendations to this commission as follows. There must be an application of the norms and standards to temporary accommodation by the city, noting that the more permanent nature of housing initially intended to be temporary, and particularly in instances where such alternative accommodation is likely to exceed a 12-month period. Chairperson, again, I make reference to the case of MBV and I believe Egutuleni, which are TAs that have had people living in there for over 8 years. And they're in the state of TEA because they were meant to be TEAs. We submit that the National Department of Human Settlements, together with the relevant provincial authorities, must establish simplified processes for municipalities to have timely access to budgets required for the implementation of EHP to facilitate the provision of alternative accommodation as a matter of urgency. This includes a fair assessment of the applications for the rollover of the funds. Chairperson, you would recall that in cross-examination, the Human Rights Commission cross-examined the city on the failed applications for rollover funds. I think it was for Mai Mai and Rabi Ridge. The city should be mindful in perceiving communities as opportunistic and avoid using language such as jumping the queue when referring to emergent situations where the use of EHP is applicable. The city
and your reference with regard to the evidence before me on jumping the queue?
I think I don't have the transcript reference number, but I think it came out in Mr. Qili's oral testimony and written statements. I apologize, Chair, I don't have the page and paragraph
number. With regard to
number.
part 2, there was no such reference. Mr. Qili gave evidence with regard to part 1.
I take the correction, Chairperson.
Yes.
The city, through its agencies such as JOSCO, must develop systems to accommodate unemployment and irregular employment, as well as other so-called gap markets. We make this submission, Chairperson, because in the testimony that has been brought by Seri before this commission, I believe it's the testimony of Mr. Mahlangu, it was raised that people who have irregular employment are unable to access affordable or low-cost housing through JOSCO because there is a rigid system that requires a pay slip. We submit, Chairperson, that the city must develop proper systems of profiling or having audits to identify who exactly lives in these buildings, particularly the unlawfully occupied buildings. To distinguish, this would be to distinguish between those who have established power over a building and the occupiers who are vulnerable to exploitation. The city must establish a relationship with the occupiers, informing them of what their dual responsibilities are in relation to the low-income rental or social housing function. And under the subparagraph in our recent submissions of upgrading of informal settlements, I think Chairperson is at page 21 of our written submissions, paragraph 74.8. It commences there. We make these submissions, Chairperson, even though we are aware that the issue of informal settlements has been contentious during the proceedings, but it is our submissions that during the inspections, the Commission experienced informal settlements such as Begezela. So they do form part of what we believe the Commission should consider. And we submit that the Gauteng provincial government, in collaboration with the city, must urgently develop annual forecasting mechanisms to anticipate and accommodate new economic migrants into the city. This also applies to the buildings that do not fall under the category of informal settlements. We submit that these mechanisms should further provide for the monitoring of existing and newly established informal settlements in order to enhance the city's ability to plan for and upgrade informal settlements. Again, Chairperson, this is not just only for informal settlements. We make these submissions even with regards to the bed buildings in the inner city. The city must obtain reports on the structural integrity of its buildings to ascertain whether the buildings can be rehabilitated and how that can be done. And in respect of privately owned buildings, the city must implement its problem property bylaws. In instances where the relocation...
Mr. Tole, what do you make of the evidence that has been presented to the Commission with regard to the implementation of the bed property buildings? How do we implement it, having regard to the evidence that is before us?
Chairperson, our submissions is that the city doesn't know whether the problem property bylaws can be implemented or not, because it has not taken that first step based on its hesitation of it being constitutionally suspect.
But the evidence is that it's under review.
In that case, Chairperson, we submit that the city should be put on task to finalize the review within a specified period of time. And I say this, Chairperson, having in mind the proposition you made to Mr. Brickhill about the recommendation for 6 months. I would submit, Chairperson, that 6 months in this case is appropriate.
Okay.
Because the city has had these bylaws under review
Yes.
for an unlimited time.
Yes.
It needs to get to the final stages
Yeah.
of the review.
So you would amend your recommendation that it must implement?
Yes, yes. So I would amend, Chairperson, my recommendation to say it must finalize the review within 6 months and thereafter implement the problem property bylaws.
Yes.
But just to point out, Chairperson, this does not stop the city from doing the structural integrity reports on buildings owned by it. We still maintain that submission that the city should obtain reports on the structural integrity of its buildings.
Yes.
So that it's able to ascertain whether they can be rehabilitated or not.
Yes.
Thank you, Chairperson. And insofar as basic services are concerned, we submit that the city must develop an indigent register to reflect those who qualify within a municipality and use such the register to provide the rebates for indigent residents of unlawfully occupied buildings. I am alive, Chairperson, to the issue that the city contends that it's unable to register to use the ESP rebates because it has the account for private property owners. But it's our submission, or rather we agree with Seri, that if the city is able to have an account for residents, it can use that account to provide the rebate. In instances where it becomes necessary to suspend the provision of services after having considered all relevant circumstances giving rise thereto, we submit that the city and its entities must follow due process and provide notice of termination to all affected individuals and not only the owners of the properties. We further submit that where services have been suspended or terminated by the city after following proper procedures, the city has an obligation to provide the occupiers with temporary services such as water tankers in the case of access to water. We submit, Chairperson, that the city should ensure that in the event of temporary accommodation periods exceeding the period of 12 months, the norms and standards applicable to housing developments must be applied to those temporary accommodations. And it is our last submission, Chairperson, that the city must take reasonable steps to maintain its properties and prevent them from reaching the state of deterioration in order to eliminate the risk to the health and safety of the occupiers and to guard against the necessity of conducting forced evictions or evacuations. Those are our submissions, Chairperson. Thank you.
Ms. Sitole. Mr. Siminya.
Subject to your direction, Chair, we may do one of two things, either take lunch or I proceed and we take lunch in 30 minutes when I'm done. If it is of no inconvenience to others at the same time.
Yes, you may proceed, Mr. Siminya.
Thank you, Chair. I see my colleagues are nodding in approval.
The chair has directed. Mr. Mr. Sidimedi?
We are comfortable with that proposal, Chair.
Okay,
We also.
thank you.
Chair, I invite us to go back and look at SERI and its oral submissions in relation to the ESP. Spend a little bit of time on that, ultimately suggesting that there is a provision of this ESP in 3 buildings. And it is because those 3 buildings have a consumer agreement with committees in there. That prompted us to go to Mr. Brickhill and say, please bring those consumer agreements you spoke about. The documents they gave us today, there's not one single consumer agreement. So it is unhelpful to use this type of diversions. We were not talking about whether or not the city can conclude a AOD. Of course, it can conclude that with anybody it chooses to. Those people don't have to be registered in terms of any legislation. It's an acknowledgement of that. That's what it is. Now, it's an unfortunate diversion because even when Mr. Brickhill makes a concession, he still uses the word if, as if it's a conditional retraction, because it is capable of 2 meanings. It's not. Secondly, if we look at the 3 buildings they're giving us, one building is of that 7-building project in 1996, when President Mandela was still in office. So you can't use that type of example to explain Usindiso. 2, those people were granted ownership of that building, so they could have meters. Now, to say that there is an example of building that has a consumer agreement providing ESP is factually incorrect. It is not evidence-based. The other building is a sectional title owned by the city. So it means it has owners. The other one is privately owned, but it's a sectional title. So why do we spend an examination of 3 buildings that are irrelevant to the provision of the ESP? And 2, when we look at the statements, under ESP is 00. It means they were never offered expanded social packages at all. This brings me, Chair, to say, one of the things that Advocacy 101 will teach you is that matters, findings, recommendations have to be evidence-based. The Commission can make recommendations however laudable without a predicate of what the evidence it has received. And that evidence must inform the factual findings that can be made. But it's because the evidence is there. And the recommendations must mirror those factual findings that has been made. Once you have a dislocation, you are very well at risk to be subject to review. Beautiful as they may be now. Kosa came here who speaks on the provision of electricity as an on-the-ground witness. He's not engaged when he was recalled for cross-examination. And it was not put to him that, no, Kosa, you're wrong. We actually have buildings where you have provided this electricity and you have provided the rebate, and it must be spread across the spectrum. There was no such evidence. Even if we were minded to go in that direction as a commission, you can't make it. And that's the second thing that we have to say. Chair, the Premier was cautious to make sure that he targets not social affordable housing as a problem for the city. That's not the mandate of this commission. That as a factor exacerbates outcomes that are like Usindiso, can be taken as accepted. Nobody contested that. But we keep making other cautions about this type of things, Chair, that let's remember we are in a commission. Now, if you say, as Serit encourages us to do, let's look at the first recommendation. The city should take reasonable measures to provide affordable housing to those who lack access to adequate housing in Region F of Johannesburg, including allocating appropriate budgetary resources and developing and implementing reasonable plans. Now, as a commission, you can't recommend that Section 26 of the Constitution must be applied. How can that recommendation ever have legal standing? Because the Supreme Law says exactly this. Now, they must produce evidence that tells us appropriate budgeting did not happen so that we can make this finding. No such evidence was produced. Of course, it looks ex facto that 11 million and whatever 15 million is not of the quantum that can address the problem. But we need this type of evidence. We need to engage witnesses, and we need to make factual findings that echo the evidence. Otherwise, you can't make them. And it is important that we understand the correctness and accuracy and lucidity of the language we use in describing this type of recommendations. It is one thing for the Commission to say those buildings which have committees and those buildings that do not have committees, the latter should be encouraged to create structures that will help interface between the tenants and the city. You're just encouraging them to do it. You can't say they must do it when those committees have no jurisdictional standing. They are not juristic bodies. You don't know whether they have a constitution. You don't know what is happening in those buildings. If SERI was minded to take us there, they should bring that and say, this is the evidence. We have a constitution. We have this. We have that. This is the cycle of office bearing in this type of buildings. Is it for 6 months? Is it for 3 years? What is the electoral system for those committees, and what is their legal relationship with the city? No, Chair, we have to be careful how we frame these things, and in doing so, being mindful that we are a commission. If it was a court of law, different ballgame. Because there is a rule of law that enjoins all of us to abide by the law. And there's judicial authority in terms of the Constitution that gives judges the power and courts to make binding rulings. You don't have that, Chair, and you raise an important point. The TRC Commission's finding are yet to be implemented. When was that? In 1996, 7? It is a structural difficulties associated with commissions. We call them judicial commissions of inquiry, but there's nothing like that in law. They are judicial commissions. There are commissions of inquiry presided in the most by judges. And I think the motivation for it is that presided over by a judge gives them a format, there are structures, there's an understanding, but it also makes sure we have Commissioner Mabena, who is the civil oversight that goes to see that everything is going, and it addresses issues that emanate on matters of public interest. That's why it is designed that way. Now, when we look at the recommendations that are made, they either want to reassert the law, and that's why we went back and said, Chair, we've listened to all the evidence. Nobody has said this policy is insufficient. This statute is wrong. This provision is wrong. We haven't found that. What we have seen is that inconsistent with the operation of the law, the application of bylaws, the city has not complied with that. The owner has not complied with that. Now, I'm making another salutary point here. Where the law places an obligation on an owner, the commission can't place that duty on an occupier who is in that building unlawfully. It's not possible. Now that brings me yet to another point. Your basic interpretation of statutes will tell you that you can't read owner to mean including an unlawful owner or occupier. It can be. Otherwise, even owner can mean an unlawful owner. But you don't reason that way. But there is a precise reason when a statute is intended to address that category and class of people. It uses the word unlawful occupier, and that's what we find in PI. So where the law is minded to address a particular class of people, it uses accurate word for that. Now what SERI does, it extrapolates occupier and says that occupier includes an unlawful occupier. But there's no such instrument in our law that gets you there. You must assume that the owner is an owner as we understand it in law. You must accept that an occupier may be a lease right holder, occupying a building that they are not an owner of, but they're doing it legally. Now, even when we make our recommendations, Chair, I would caution, they must not go and change what the law says in relation to this. Firefighting, I appreciate Mr. Craig's evidence. Firefighting has a body of law about what a building must have and not have. So the problem is not the law. The problem is the obligation discharged by whoever is being referred to in that statute? And if it is not, then commissions can come and say, you may want to consider A or B or C. And you're right, Mr. Brickhill, you can't use the must, as if non-compliance can be visited with criminal consequences or even civil consequences. So we want to embrace, and I'll illustrate the point. If the word hijacking has residual connotations, nuances, innuendos, that it is criminalizing or directing itself to tenants, that's unfortunate and that's wrong. I agree with Sarah on the point. But the type of recommendation from a commission should say, caution must be had to the use of this word. It holds a risk of being injurious to people it does not intend to injure. That's okay. We can live with that type of recommendation, but not this type of telling officials never to use a word. If they do, what do you do as a commission? You can subject them to any sanction. And the law about this is also resident elsewhere. Whether it is in criminal law, whether it is in delict or other areas of the law, that's where the forum and the exercise and the fight must go. But we need to contain ourselves within the realms of what is competent by a commission. And we started by saying, one, you can't operate outside your mandate. We did go and reference other places, including a possibility of seeing whether solutions can be there in Cape Town. We didn't get that far. But the factual findings that are competent to be made are factual findings that find expression on the evidence. Now, we are told we should go to this statute. If I can be granted just a moment. What are my notes? What are my notes? My notes. Oh, here. The Section 3.1 of the standardized bylaw. You don't do that again. There's nothing wrong with this bylaw. And it is now being used to say it can provide a rebate facility to an unlawful person. It doesn't go there. So to avoid what Mr. Brickhill says is a potential risk of review, we are now constrained to be very careful in what recommendations the Commission can make. Again, iChip. I can see why the Commission can say a program of that nature, when implemented within the means available, will mitigate seriously the exposure that has happened in Region F, which is where the Commission is sitting. I can see that type of recommendation come through. But to say the Council must implement iChip, what if it doesn't? But should it be encouraged to consider its review as the evidence suggests it is? It's perfectly proper for the Commission to say, even the acting executive manager concedes that it's unfortunate iChip in its proposed... The city manager, sorry, Chair. It's unfortunate that iChip did not see its last stage being presentation before council. But he is clearly wrong to suggest it is a strategy that does not require council consideration. And I can explain why. It is a program requiring a budget allocation. Who can give the administrator the money if not the council? The power of appropriation lies there. So you can't just go and table it for noting. Surely, in noting it, they must then consider, does it have financial implications on the city? If the answer is yes, then it must go through the budgetary process. If approved, that budget then would be allocated to the program. That's what the law says. So, as I'm repeating myself, encouraging a review, revisitation of what may seem to be a possible solution for the city enveloping Region F, it must be encouraged to look in that direction. And we cannot offer this as a binary. Are you going to be I-chip or are you going to be bed building strategy? The two are not mutually destructive. And I don't see why a revised I-chip-like strategy may not learn from what would be experienced with this bed property buildings strategy. That can be complementary. And it's perfectly okay to say in a commission's findings and recommendations that a consideration to see where those can be mutually enforcing. Such a course be encouraged. I can see that. But they can't be framed in this way. Timelines. Even with timelines, Chair, you need to know how the cycle works before you can put 6 months, 3 months, or whatever else is there. And you do that through the evidence-based platform. Call those people and say, what is the program for the year? And see whether or not reasonableness requires they interrupt that. But you can also competently say in a commission, the consequences of non-compliance with the bylaws is triggering and continues to trigger threat to life and limb. So, council, consider prioritizing fire risk containment as one of your top issues because they are life-threatening and they are a threat to limb as well. Nobody can complain with that. But you can't prescribe that they have to do it within a particular time frame because the Constitution, as where I started, already has that provision. If they're not observing it, you don't go to a commission, you go to court and say, this is a failure. Now, what SERI does, it concludes that this is inadequate and therefore the city has failed to achieve it, and therefore the commission must make recommendation that observes that failure. It can't go on like that. Even when it sounds right in my ear, I can't find the evidence of what would be adequate and what falls short of adequate. But to go there, I would need to go through that program. For instance, and I'm making example, Chair, so that everybody can understand where we are as the evidence leaders. The city should review, says paragraph 4, and present I-chip to the relevant city authorities, such as the mayoral committee and council, as the law may require, for consideration, and I add, and possible adoption. You can't say an adoption. Are they having no discretion whether to adopt or not? But again, the qualification and the language you use must be competent within the power of the commission to achieve and realize. Now again, and not for any bad reason, Region F falls within the city of Johannesburg, and it's a responsibility in law of Johannesburg City. But this commission is not a city commission. We need to remember that. This commission is established by the Premier, and if we make recommendations, we can say to the Premier, please alert the city to this type of shortfalls. Even the Premier can't do anything about it because, as we know, the Constitution has schedules of competencies. What the city is entitled to do, no other level of government can do unless certain constitutional prerequisites are shown to not exist. So we're not writing the law here, Chair, if I can say that loud. There are a whole plethora of instruments that intersect to govern a society. Where we fail, it's not there. We fail in not living up to the text of all those instruments in their implementation, acting appointments. It is a problem, but we can address its consequences because on law, acting appointments have a life period. And there's nobody who's complaining that that life period is short, is long, is too long. The complaint is the reverse. You're acting inconsistent with the timelines for acting appointments. You keep renewing them. What can a commission say? A commission can only say renewal of acting appointments for executive position are in themselves a hazard if they get kept on extending and extending, where positions should be filled by permanent people. That you can say. But we must be careful even how that gets said. It is the undesirable consequences that arise when the law is not observed. We are told that the JMPD is going to be looking on a ward-based process about addressing questions of crime where those are present. But what is that? And why is it different? We don't know. So I'm cautioning us, and I was listening to the city's submissions as well. It is not words that are going to address this problem. When the commission stops with its work, that's going to be the end of it. So we need to say, we have had the promise. We're unable to evaluate it within the time constraints that are here, but because they sound right, serious consideration must be given in how they can be implemented to realize what is an admitted goal. ESP. Nobody's arguing that there is a class of people it envelopes who ought to be outside it, or there are people outside it who are supposed to be inside its fold. Of course, that is obviously even an admitted evidence-based concession. The problem is, how do you deliver it? And nobody has offered an alternative. Now, what can the commission do? You can't write the law. You can't change the law. But I'm sure we can say as a commission somewhere down the line that it is regrettable that the majority of intended beneficiaries of this ESP, which is a constitutionally promised right, is not reaching what it should. As we are making a proposition with one of the witnesses, surely you can provide lighting for escape routes only then. But you must do something about it because we have seen that smoke, according to Mr. Craig, is a serious impediment. And is saying, don't use corrugated iron. Because in 3 minutes' time it's gone. The heat it generates, I thought he mentioned something like 600 degrees. There's no opportunity of escape there. So, Chair, I can go through all of this one by one, but I think the criticism is a consistent one. We can only do what a commission can do and use the language that it can use and understand its reach and legal standing. And for instance, Chair, if you have under 15.1 a recommendation that says SAPS, GMPD, GFIS should desist from using police raids unlawfully. As a matter of law, they can't use that thing unlawfully. So what are we saying as a commission? I'm exaggerating the point for effect. A commission can say you can't commit murder. Of course, in law you can't. What the commission can say is, unless these constraints are put in place, the incidence of murder will increase. Yes, the commission can say that. But I don't want to make that point higher than now, Chair. I'm just alerting other parties what, as evidence leaders, we think is possible to do given the mandate of the commission. Those are our submissions, Chair.
Thank you, Mr. Semenya.
That chair would, subject to direction, that chair would take care of the formal component of the hearings in Part B. The terms of references amended now direct the Commission to sit, consider, and submit its report by no end of the month coming. Again, thanks to everyone.
Thank you. Well, colleagues, I wish to express the Commission's profound gratitude to the evidence leaders, Mr. Semenya, Ms. Platt, Mr. Pizzo, to MNS, Mr. Sidumedi, Mr. Mnyandu, to Seri, Mr. Brickhill, and Mr. Tobakale, to SAHR, Ms. Sitole, for their written submissions. They were extremely helpful. And I also wish to express our profound gratitude for the presentation of the oral arguments that were made before this commission. Their contribution has enabled this commission to execute its mandate. We are grateful for your participation. We have now come to the end of the formal proceedings of this commission. What is left now is for this commission to table its report to the Premier. I thank you. We are adjourned.